honourable member for Timmins James Bay.
Thank you, Mr. Speaker. It's an honour to rise here to speak to Bill C-32, a bill on establishing a victim's Bill of Rights for Canadians, and certainly we as New Democrats are very interested in the issue of this going forward, and there's a number of provisions that we're particularly interested in. One is the widening the definition of victim, and also the creation of a complaints mechanism for victims to file a complaint to a federal or provincial agency if they feel their rights under the Charter have been denied. I'm looking at that provision in particular this week when the survivors of St. Anne's Residential School were once again in court, Ontario Provincial Court, over this government's obstruction of a provincial court order, calling on the federal government to release thousands of pages of police testimony regarding the crimes that were committed against the children at St. Anne's. So when we talk about victims, I think it's important that we say that under this government there's two kinds of victims in this country. And unfortunately, the First Nation victims, their rights continually to be undermined. Under the Indian Residential School Settlement Agreement, a legal agreement was put in place because Canada was found to be the defendant in thousands of cases of physical, sexual abuse, psychological abuse against First Nation residential school children. Under the Residential School Agreement, the independent assessment process was established that was supposed to be non-adversarial to allow the victims of these horrific crimes to tell their story and be compensated. But the people of St. Anne's found out that this process has been anything but non-adversarial. So I'm going to be certainly looking at Bill C-32 in terms of the complaint mechanisms that need to be in place for victims. Under the Indian Residential School Settlement Agreement, the Government of Canada, the Department of Justice, played two roles. One of the roles was to be the lawyer for the defendant. The defendant of these crimes was Canada. So they were there to defend Canada's interest. But they were also there to create the evidence narrative, to provide the court, the hearings, with all the evidence that the claimants needed, and told the claimants, you don't need to bring your lawyers, you just need to come and tell your story. The evidence will be there and we'll look at it. But what happened to the people from St. Anne's was that when they went into the hearings, they found that the federal government had prepared a false evidence narrative, and a narrative that was essentially a lie that was presented to a legal hearing. The narrative stated there is no known documentation of sexual abuse at Fort Albany Indian Residential School, no known incident documents of sexual abuse at Fort Albany Indian Residential School, so that victims who came forward to tell their stories were being challenged day after day by Department of Justice lawyers who are saying there's no evidence to back up your case. Now, what the federal government did not tell the survivors, nor the adjudication process, was that they were sitting on thousands of pages of police testimony of the horrific crimes that were committed at St. Anne's. In fact, in a 2003 affidavit, the federal government obtained this information from the Ontario Provincial Police that identified 180 perpetrators of physical and sexual abuse, including the actual torture of children at St. Anne's, from 154 different plaintiffs. They also collected over 860 witness statements that verified the crimes. Now, many of these criminal acts were not it was not possible to prosecute them in Ontario court because many of the perpetrators had disappeared, they couldn't track them down, or they were dead. But there were a number of criminal convictions that came forward. One of those criminal convictions was against a woman, Anna Wesley. So the federal government was aware of these horrific crimes. They had the evidence, and in their 2003 affidavit by the Justice Department to obtain this evidence, they told the Ontario Provincial Court at that time that it would be unfair for the defendant. Unfair for the defendant if they didn't have access to this information. But what was unfair for the defendant was considered perfectly fair that the survivors, the victims, went in without this evidence. And in the 2003 court ruling, they transferred this evidence to the federal government and said that future plaintiffs should have access to this evidence. That didn't happen. So the government lied to the survivors of St. Anne's. They lied to the independent assessment process, and in 2012, as the process was going on with claimant after claimant was being challenged over the fact that they had been put in homemade electric chairs for the amusement of the staff or being forced to eat their vomit when they were sick. And the federal government was saying, you have no evidence to back this up. And the lawyers found out that they had this evidence and challenged them, and the federal government said, we don't have to produce it. So the very federal legal institution that was there to protect the victims were defying the independent assessment process. In July 2013, I wrote to the Indian Affairs Minister and asked, how could it be that the government would have produced a false evidence narrative and suppressed evidence in a legal hearing? He wrote to me, quote, Canada is, of course, aware of the Ontario Provincial Police investigations regarding St. Anne's residential school and resulting trials. But then he said they had no legal obligation to seek out the documents. He didn't say they were sitting on the documents, that they had the documents. He then said the evidence was not admissible. This is what he said. Statements made to the Ontario Provincial Police in the course of their investigations cannot, in Canada's view, be used as evidence at the independent assessment hearing. Only oral testimony of a witness is considered evidence. Well, that's not true. That's another falsehood. The terms of the IEP state that relevant findings in previous criminal trials may be accepted without further proof. He stated then that corroborative evidence does not need to be submitted to corroborate the oral testimony of the claimant. And this is one of the key elements, because the independent assessment process actually states, quote, the standard of proof is the standard used by civil courts by matters in such like seriousness. Although this means that the alleged acts become more serious, adjudicators may require more cogent evidence before being satisfied that the claimant has met their burden of proof. So the survivors who went into that process were lied to. They were told, you don't need to produce evidence, just come and tell your story, when it actually says, if you're making serious allegations of criminal acts against children, you have to prove it. They sat with all the access to the evidence and told these survivors that they were making things up, that they had no evidence to back it up. So on January 14th, 2014, this was heard at Ontario Superior Court, and Justice Perrell stated that Canada had a legal duty to search for, collect, and provide a report on the crimes that were committed against these children. He stated that Canada's failure to produce OPP documents about St. Anne's has compromised the independent assessment process and denied the claimants access to justice. And yet this week, these same survivors were in court again because in spite of a provincial superior court ruling, they went back into the hearings and said, no, we're not producing the evidence. No, the evidence on Anna Wesley and the crimes that she committed against children and the corroborating evidence that was used to convict her, we will not turn that evidence over. They said this to people whose only crime was that they were children, First Nation children. They told the Ontario Superior Court they couldn't explain why they had produced a false evidence narrative. They didn't know it was maybe an accident, but that's not true. On July 26, 2013, after I wrote to the Indian Affairs Minister, they began an internal rewrite of the narrative. And it's called Amendments to St. Anne's Indian Residential School in response to the member for Timmins, James Bay. So think of that for a moment. That the top legal system in this country that is there to protect the interests of the law and citizens of Canada only started to create a clear evidence narrative after they were being outed. Otherwise, they would have continued with the misrepresentations and falsehoods. Now, Edmund Matatawaban was in court again this week. Edmund is the spokesperson for the survivors. He has to fly down from Fort Albany on his own dime. He's been trying for years and years to get this government to work with them. Instead, all they found is abuse. And he wrote to the Justice Minister, he said, my God, we were just children undergoing torture and abuse. The federal government was conspicuously absent and negligent to give us solace protection, and nothing has changed in 2014. I want to end, Mr. Speaker, by saying that the government spends about $106 million a year in Indian affairs fighting the rights of First Nation people. That's almost double what they spend going after tax cheats or criminals. I'd like to end with a quote from Doug Cuthan in the Star Phoenix. He says that the federal government has adopted an expensive two-pronged legal strategy, that it conducts a scorched earth legal strategy that drags out cases and starves First Nation organizations of funds. Sitting down for honest negotiations is simply not part of this government's strategy. They made an apology to Canadians, and they undermine that apology. They see there's only two kinds of victims, and First Nation victims are never part of their narrative.
Questions and comments? The Honourable Member for Toronto Danforth.
Thank you, Mr. Speaker, and I thank my colleague for a truly impassioned speech that also reveals a lot that I think Canadians do not want to hear, because they can't, I'm sure they couldn't believe our government is capable of this kind of, frankly, lawyering. And I'm wondering if my colleague would agree with me that the time might have come for the need for some kind of a task force on the ethics and professional responsibility of the federal government's lawyers. I'm thinking about the residential schools case that we've just heard. I'm thinking about the role of government lawyers in the Afghan detainee situation before the Military Police Complaints Commission. I'm thinking of the current privacy commissioner who argued before the, the Committee Against Torture at the UN under the Liberal government that people could be deported to a substantial risk of torture if they are serious criminals. And I think of the farce of the constitutional compliance review that supposedly goes on in the Department of Justice, which we all know does not. Lawyers should not simply be mouthpieces for unconstitutional and otherwise unethical government policy, and I'm wondering if my colleague would agree with me that it's high time for a task force to look into this.
The Honourable Member for Timmins James Bay.
Thank you. I have deep respect for my honourable colleague, and I think his question on a task force is very important. When you see that the lawyers for the Justice Department of Canada went into those hearings and lied and produced evidence that was a lie, that suppressed evidence, if that was in a normal criminal proceedings, there would be people whose licenses would be taken away, the cases would be thrown out. But in the case of the Indian assessment process, independent assessment process, the position of the courts and apparently the independent assessment process is, oh, well, we got caught, life carries on. And they go back into the hearings and they act as Edmund Matadawabin said, poisonous in their treatment of people whose only crime was that they were children, First Nation children, and they were taken away from their families. That they act in defiance of an Ontario Superior Court ruling, that they act in defiance of the basic laws of this land in terms of the obligation for disclosure and the obligation as a federal government, the so-called honour of the Crown, to produce evidence that's not a fraud. And they think that this can carry on. I agree with my honourable colleague. Something must be done.
Question complémentaire, l'honorable député de Hochelaga.
Oui, Monsieur le Président, ce n'est pas une question, c'est un commentaire. Je suis complètement dégoûtée parce que je viens d'entendre par l'hypocrisie d'un gouvernement qui dit qu'il veut protéger les victimes d'un côté avec un projet de loi et d'un autre côté qui fait ce genre de choses-là. Mon propre voisin, ici le député de Abitibi, Bay James, Nunavik et You, son grand frère est mort dans une de ces écoles-là. Sa mère l'a su par hasard plusieurs années plus tard. La famille n'avait aucune idée de ce qui était arrivé. Alors je trouve ça complètement dégueulasse qu'on protège une partie de la population, qu'on dise qu'on protège une partie de la population, mais d'un autre côté, il y a une grande partie de la population, tous les Autochtones qui ne sont pas protégés, les femmes disparues et assassinées. On ne veut même pas faire d'enquête là-dessus. C'est hypocrite. Alors, j'aimerais avoir le commentaire de mon collègue, s'il vous plaît.
The Honourable Member for Timmins James Bay.
Thank you, Mr. Speaker. I think as Canadians, we saw that historic moment of the apology and we thought that things would change. We took our government at their word. We see with the disappeared women, I think of Shannon Alexander and Maisie Ojic, two young students, top marks, walked out of their home one day in Kittiganzibi and were never found again. And nobody ever seemed to go looking. I saw the family a year later putting up posters. Is there supposed to be an inquiry? Hell yes, there needs to be an inquiry. And yet we saw the Justice Minister take all the documents, the supposed documents about these women and their lives and what happened to them, threw them on the floor of the House of Commons. And then they stand up and they talk about victims. They stand up and they want their pictures taken with the so-called victims. They wouldn't stand out on the House of Commons when the mothers and the daughters and the sisters stand out there. It's a crime. And it's a crime against the larger humanness of this government and this country when you relegate a section of our population to say that they don't count, that you can abuse them, that you can take away their rights, and you can go into a legal process in 2014 and lie in a court and say, we're the government of Canada, we will lie if we want to. That's not acceptable.